I said no cameras.
Let's go.
Why is he pointing a camera at me?
I'm just upset. I'm disappointed.
You must change. Otherwise, you will end up dead.
The courtroom in Brooklyn was in chaos during a hearing. Stephen Adonazzo, the man accused of making racist threats to his black neighbors, rejected 2 plea deals and even cursed at the judge. While waiting for Adonazzo, he was heard ranting outside before the proceedings started. He was clearly agitated, and his defiance was obvious. He turned down 2 separate plea deals, including one offering him 2 years in prison, even though his attorney warned he could face up to 15 years if the case went to trial.
I said no cameras.
Let's go.
Why is he pointing a camera at me?
An agitated defendant entered the courtroom, objecting to the presence of cameras. The 69-year-old faces felony hate crime charges for making racist threats against his black neighbors in Brooklyn. He claims that the attention on his case is targeting him in jail, though correction officials have not been able to confirm this.
Okay. We gotta go this way.
No cameras. No cameras. I'm getting beat up at Rikers. No cameras. They're beating the crap out of me.
Previously, the Brooklyn DA charged him with making terrorist threats, leading to his eviction from his apartment. This came only after it was found that he had waved knives and threatened to burn and kill his black neighbors in the Evansfield apartments. Despite a year of calls to 911, 311, and local officials, no action had been taken. He was the NYPD's prime suspect in a fatal arson that killed an elderly veteran on his floor. Just 3 days before that deadly fire, a neighbor recorded him making these threats.
We're gonna burn you. That's really brown. When we get done with it, you'll be black.
However, police say their arson and homicide investigations have stalled. Now, he is only accused of making threats. He refused to plead guilty to a Class B felony in exchange for 2.5 years in jail. He also rejected an even better offer of 2 years in prison from the judge, who stated, "I can't do any better than this."
There's no purpose in him being in jail for 2.5 years. He needs help.
His defense lawyer stated that he has requested mental health treatment for his client instead of jail time, but prosecutors have not agreed. Adonazzo raged at the judge, shouting, "I might be many things, but I'm not a terrorist. I was a patriotic American. F you," before adding, "Excuse my language," as he exited the court.
He belongs in the program. He needs some help.
The district attorney's office stated they would review any request for a mental health evaluation. In the meantime, the case will proceed to trial. Family members of murder victims had their say as a man admitted his role in a deadly revenge shooting. Tony Putidi pled guilty to aggravated murder in the deaths of 2 men in a drive-by shooting. Prosecutors described the case as a murder-for-hire retaliation for a previous shooting. The drive-by occurred just hours after the funeral service for one of the prior shooting victims. It happened during one of Hamilton's most violent summers, on August 3, 2016. Orlando Gilbert and Todd Barris were shot and killed on Central Avenue in Hamilton. According to prosecutors, this was in retaliation for a shooting at a bar on Hamilton's west side. Tony Putidi, the trigger man in the drive-by, pleaded guilty. Police say Putidi fired an AK-47 into a Ford Mustang, killing Gilbert and Barris. Before sentencing, Barris's family spoke in court about the profound loss they are enduring.
I think about precious little Thea, Todd's beautiful baby girl that will never get to know her daddy. Todd would have been a good father, but because of you, he will never get that opportunity, and he will never see his little girl grow up.
Assistant prosecutor Brad Burris read a letter from Todd Barris's mother.
I was my firstborn and my only son, and you took him away from me, his sisters, his nephew, his daughter, and all of his friends and family. Because of you and your actions, our lives have been destroyed.
Prosecutors stated that Orlando Gilbert was the intended target. His father, Leroy Brown, spoke directly to Putidi.
Only you can look at the judge who holds your fate to your freedom, but you can't look at the family members of those you harmed. My wife just wants you to look at her.
Judge Greg Stevens told Brown that he could not force Putidi to respond, but then Putidi did just that.
You just look at them, Tony. Look at them. Those are the people whose lives you affected.
Putidi held back tears as he looked at the family members. One of his attorneys mentioned that he does feel remorse. Following the shooting a year ago, city leaders in Hamilton, along with police, pleaded for peace in the community. Putidi is the third person to plead guilty for their role in the deadly drive-by shooting. She and her family were left brokenhearted following the sentencing of a man convicted in a deadly hit-and-run in Sherwood in 2019. The victim's family is disappointed by the outcome. Will Farrell will serve 10 years for both counts of negligent homicide and fleeing the scene, with the sentences running concurrently. The judge noted that Farrell did everything he could to cover up the crime, including fleeing the scene and selling his car before his arrest. However, Dole's wife expressed that the judge's sentencing is more than disappointing.
I'm just upset. I'm disappointed.
The heartbreak for Kimberly Mundell, who became a widow 3 years ago, continues. She is filled with disappointment after Cecil Farrell received his sentence for the deadly hit-and-run that killed her husband, John Mundell, while he was cycling along Highway 107 in Sherwood back in 2019.
I wouldn't wish this on anybody.
Farrell was convicted of negligent homicide and fleeing the scene and has been sentenced.
10 years on one charge and 10 on another that run at the same time. He gets credit for time served.
Mundell spoke directly to Farrell in front of the courtroom before his sentencing, detailing all she had lost in this tragedy and asking the judge to impose the maximum sentence of 42 years.
Here and then having probably my worst fear of coming true. I poured my whole heart into this statement, and based on some of the comments that were made, it sounded like that it did make an impact.
Mundell expressed that seeing Farrell potentially serve less than a decade behind bars does not bring the justice she needs to move forward. She shared that she had just gotten married less than 2 months before her husband was killed.
But like I said in my statement, no one should have to say goodbye 58 days after saying I do.
Mundell said after the sentencing that despite feeling hurt by the sentence, her focus is on moving forward, not on moving on.
Forward in a lot of ways, and I think this one's going to take me a bit to process.
The judge acknowledged today that Farrell should not have been driving at the time of the crash, since his license was suspended. Kimberly Mundell said she was shocked by the judge's sentencing decision because of this fact. Now, she fears that once Farrell is released, he may choose to get back on the streets and put lives at risk again. A retired Norwell doctor appeared in court facing dozens of charges. The doctor insists he is innocent.
Commonwealth versus Richard Kauf. This case is called for arraignment. The defendant is approaching the bar.
Retired Norwell pediatrician Dr. Richard is accused of sexually assaulting 24 of his patients. With the number increasing by 22 after 2, alleged victims came forward. The former pediatrician is now facing numerous additional charges. He pleaded not guilty to all charges.
Rape of a child with force in violation of General Laws, Chapter 265, 22A. Guilty or not guilty?
Not guilty.
How do you plead to count 3 of that indictment, wherein you were charged with the crime of indecent assault and battery upon a child under the age of 14 years in violation of General Laws, Chapter 265, Section 13B. Guilty or not guilty?
Not guilty.
His attorney spoke on his behalf outside of the courthouse.
These allegations are spurned by civil suits that have been filed and complete hysteria. This was a very upsetting day for him, and he is absolutely innocent.
The investigation began after 2 women connected in a social media group and started questioning if their exams were normal. According to the prosecution, all victims had similar exams that took place over several years, starting when they were just 8 years old. After his first round of charges, Dr. Richard was released on a $50,000 bail. That bail was transferred under the condition that he have no unsupervised interactions with minors, except for his young grandson, and he vowed not to practice as a pediatrician, among other requirements. Eddie Burns pleaded guilty to several charges after attacking an elderly couple in Glenville.
And I thought for sure that he was going to shoot me because I didn't know how to take the passcode off my phone.
Mr. Burns, I am afraid every time I come home.
2 guys with ski masks on, with guns, told us to hand over our wallets and phones.
Mr. Burns, you beat me so bad that the braces I have to wear on my left leg. You stomped me so hard the brace broke half in two.
It's individuals like Mr. Burns who show complete disregard for the people in their neighborhoods that are attempting to destroy this city, and I think the judge sent a message that it will not be tolerated.
A teen apologized to a teen murder victim's family before learning his fate. 18-year-old Mitchell Civikas was sentenced to life in prison for the murder of Isaiah Blue. Daniel Benavides was also sentenced for his role in the crime. Brian Daniel did not actually pull the trigger in the murder. He pled guilty to second-degree murder and learned that he'll spend 20 to 40 years in prison. Before he addressed the court, Blue's mother delivered a very emotional message to him.
You must change. Otherwise, you will end up dead.
16-year-old Daniel Benavides will spend his 20s and early 30s in a prison cell, a fate that even Isaiah Blue's mom finds emotional to think about.
As a mother, I cannot help but to feel sorry for you. You are too young to be here. You have not only stolen from me, you stolen from those that love you too. You stole from yourself.
Benavides didn't pull the trigger, but he did have a gun and was with Mitchell the night he murdered Blue. His attorney reminded the judge of this, which Seaton echoed.
Don't blindly follow selfish people. Following your brother is why you are here now. He did not think about my son or you. As much as I want to hate you, I can't. You are just a kid. You think you know how it works, but you don't know anything.
The judge sentenced Benavides to 20 to 30 years behind bars for his second-degree murder plea, plus another 2 years for the felony firearm charge. Before leaving the courtroom, Benavides had something to say to Blue's family.
I want to apologize to Isaiah Blue's mother, his friends, and the rest of his family. I'm not a good speaker and all, but these words coming from my heart. I'm not expecting forgiveness. I don't want forgiveness. I just hope and pray I get understanding that my intentions weren't for Isaiah Blue to pass away that night.
Family declined to speak after the sentencing. In the 2010 murder of an elderly woman, the last suspect in the case was sent to prison. Todd Angelique Nash had the chance to save herself a minimum of 10 years in prison if she had taken a plea deal, but she chose to go to trial. Now, she'll likely be in jail until she is in her 50s. After 3 trials and 2 hung juries, Angelique Nash was convicted earlier this year for acting as a lookout while her sister and her sister's boyfriend burglarized the home of 81-year-old Dorothy Session. The burglars were surprised to find Session at home and beat her to death. Prosecutors say Nash stood by when she could have saved Session.
The most stunning thing to me is that she heard the victim screaming for help and did nothing.
All she had to do was dial 911 and even drop the phone there. And that might have prevented Ms. Session from dying.
Prosecutors had offered Nash a deal that would have cut her sentence by at least 10 years.
We made offers that took into account her role, including the last offer was a flat 15 years.
I absolutely did urge her to take it at the time, sure. It's always better in California to know what dates you're getting out instead of leaving the realities of whether you do or not up to a parole board at some date in the future.
Nash was sentenced to 25 years to life, meaning she will have to serve a minimum of 25 years in prison.
Once she serves 25 years of actual time, she doesn't get good work time credits because of the murder conviction. Murder you don't get good work time credits. She then has to go in front of a board of parole.
Nash wrote a letter to the judge requesting a new lawyer, but the judge denied her request.
She didn't have any remorse for her actions. She basically said, I didn't get a fair trial, which I think is ridiculous.
Angelique's sister, Catella, also received a sentence of 25 years to life. The supposed ringleader, David Moses, was sentenced to life This story dates back to 2006, when someone sexually assaulted a girl and attempted to assault a girl near a liquor store on Finkel in Detroit. The victims each picked Terrence Calhoun out of separate lineups. Then, in 2007, he pled no contest to charges, including first-degree CSC and kidnapping. Calhoun received a sentence of 15 to 30 years. DNA evidence has indicated that the crimes were committed by someone else, who is now facing charges. Terrence Calhoun and his family were supposed to celebrate his release from prison in Whitmore Lake. However, it didn't happen. Everything was going as planned until a Detroit police officer showed up, claiming he had new evidence and knew the judge, and tried to talk to her. That's not how the process works, and DNA evidence has cleared Calhoun. Instead, he remains in jail. His heartbroken family had traveled from Tennessee to be here. Instead of a tearful reunion, there were tears of anguish as their loved one remained behind bars.
Extremely disappointed for Mr. Calhoun, and as you can see, his family is absolutely devastated.
The hearing to formally exonerate Terrence Calhoun was supposed to bring closure and joy, but it instead left his family in tears of anguish as their loved one remains behind bars.
Mr. Calhoun, do you solemnly swear to tell the whole truth, nothing but the truth, so help you God?
Yes.
The hearing was suspended by a Detroit police officer who showed up and claimed to have new evidence and spoke to the judge.
Judge, you've got to look at this before you dismiss this case. You have to look at this evidence here.
Judge Kelly Ramsey stated that she knows the police officer as they worked together on the Innocence Lost Task Force for years. She mentioned that the officer tried giving her a binder before being told to leave.
This is highly inappropriate for the Detroit Police Department to go behind the prosecutor's back, and I just want to apologize to Mr. Calhoun and his family who traveled in from out of state.
I think this is a police officer who just didn't like the way that things went down and felt that the prosecutor was making the wrong decision.
In 2007, Calhoun pleaded no contest in 2 sexual assault cases involving young teen girls. However, DNA evidence and a lengthy investigation have cleared him in both cases. Like Calhoun's legal team, the National Organization of Exonerees was left stunned by the recent developments.
Thought about it if it would have been me when I was exonerated, being postponed a week. My heart was already beating. I was anticipating the family. Like, it's horrible. It's just a horrible feeling. It brought back a feeling that, what if?
As the family waited outside, crying, officials finally allowed 2 family members inside to talk to Terrence Calhoun. Meanwhile, the Detroit police were not happy. They released a statement saying, in part, the events that unfolded in court today were outside of the Detroit Police Department policy and are not how the administration expects our investigators to act. The officer did not adhere to our policy or procedures to prevent such a situation. The man convicted of kidnapping, raping, and holding a woman captive in his apartment will spend up to 39 years behind bars. A judge just handed down that sentence to Victor Pena. The victim was present in the courtroom but did not speak. Instead, she gave the judge a handwritten statement in which she wrote, "A part of me died in that apartment, and I mourn for the life I could have lived." Pena was sentenced to 29 to 39 years in prison. A jury convicted Pena last week after 2 hours of deliberation. The victim, now 26 years old, testified during the trial about the night Pena kidnapped her outside a bar on Union Street in 2019. He then locked her in his Charlestown apartment and sexually assaulted her repeatedly. The prosecutors said they were asking for a murder-type sentence because rape truly does murder someone.
The horror of what he put the victim through defies description. It was sadistic, it was terrifying, it was entirely for his own control and gratification. And remember, it ended only when the police caught up to him, not because he decided to relent. Case was everyone's worst nightmare. It's a nightmare for young women, their parents, their families.
The impact of such crimes robs the soul and leaves a long-lasting, if not permanent, effect.
Victor Pena has been sentenced to 29 to 39 years in prison. The incident revolves around Corey Batty. On June 23, 2013, in Nashville, Tennessee, Corey Batty violated an unconscious woman. Once the police concluded that Corey was the perpetrator, they decided to file charges against him. To help the jury form an opinion, the prosecution presented various facts about the suspect in court, as is customary in such cases.
Ladies and gentlemen, we have finally reached the point in this trial where all of the evidence has been submitted to you. We talked what seems like a very long time ago in jury selection about that there were two components to every trial and two things that you needed to do your job as a juror. The first is the evidence. What comes in through the witness stand, through the witness's testimony, the actual physical evidence that's introduced. I think we have over 50 exhibits that you have seen and you can go back through if you choose to in the deliberation room. Which I don't mean to scare you by saying we're only halfway there because it won't take as long. But until the judge gives you the law, you can't do your job of deliberating. And after closing arguments, after the attorneys both have a chance to speak with you, Judge Watkins will provide you with that law. And that law will be the jury instruction, which we talked about this in jury selection too, that this is your manual. And while a lot of times people, it might be, yes, I've heard all of this. Yes, we've been talking about this all week. This is the law. You swore an oath that you would apply this law to the evidence. And I am going to ask you to do that. Now, of course, again, it seems like everything in this trial has been somewhat lengthy. This is not a short document. And to ensure that you hear the entire law, Judge Watkins will read it to you at the end of closing arguments. And I just want to go through a few of the things, because far back into the jury instructions, it actually tells you one of the first things that you need to know is that you must begin with the indicted offense. The law requires you to. In this case, there are 5 counts of aggravated and 2 counts of aggravated battery. You are required as jurors to determine guilt or innocence on that indicted offense. So you would all 12 have to vote not guilty to move on to any lesser included offenses. Which I tell you this because, again, if you are the type to not use the manual, when the judge reads out the jury instruction, the law requires him to read out lesser included offenses.
First of all, ladies and gentlemen, on behalf of the state of Tennessee and the people of Nashville, I'd like to thank you for your service. Leaving your homes, your family, to come here and spend a week and have to listen to the evidence you've had to listen to is a heavy burden for a citizen to carry. And we really appreciate your service, because without citizens like you, we can't function as a society. I usually stand here, and done this a long time, as you can tell by my hair and the way I look, and talk about what are the issues. Because I've never had a case that was videoed and photographed by the people committing the crime. So what are the issues? Ms. Teasley, I might agree with one thing she said. There's overwhelming evidence. She's right about that. But then it's like, ignore that. Who can we blame? Let's blame alcohol. That doesn't really work, but let's blame alcohol. Can't blame alcohol, let's blame Mr. Vandenberg. We can't blame him, let's blame Mr. Banks for feeding the story. Or let's blame technology, like she said in her opening. If we didn't have technology, we wouldn't even be here. Blame anybody except Mr. Beatty. So she goes to Mr. Vandenberg, calls him the puppet master. And that's another thing I agree with her. Mr. Vandenberg is guilty too. He's guilty in every count of this indictment. Every one of them. So was he the puppet master? What evidence do you have? Who was the first one to touch this victim, start doing anything? Mr. Beatty. And what was the only thing he was told? Put on a condom during this. Nothing else was told to him. He claims he doesn't know because he, of course, blacked out. So there's no proof at all in the record of anything like that. One of his best friends said he's a leader, strong personality. Did he look like some guy that got easily led around with all he had going on that night? He's over here at one party picking up one girl, getting texted by another girl. Then he comes down and commits these crimes and goes back and calls another girl, then calls his supposed girlfriend to come over and spend the night. Does that sound like somebody in a blackout? And then she wants you to believe fantasy story. His friends, he gets these messages on his phone, a video and photographs, and he doesn't really look at them, although he doesn't remember anything. And then they come and they tell him this story, but they don't tell him what happened. They don't say, gosh, Corey, you remember doing all this stuff? This. No, they just tell him, stick to this story. And even though he must really be struggling to be so blacked out and hungover, he remembers every detail of she was muttering, she was threw up on the elevator, went and got Quella. He remembers all of that. That's the fantasy they want you to believe. And then have the audacity to Corey Beatty. Sure, Miss Lang. And felonies. She wasn't out walking around texting for Mexican food and doing all kinds of things. And then to sit here before you jurors, sit here for 5 days and looked at this overwhelming evidence and say it's not rape? Does she think you're blind? Say it's not rape? She talked about intoxication. Let's look. We talked about the law a lot. Voluntary intoxication is not an offense to aggravated rape principle. It's not an offense to counts 1 through 4. If you find those elements been proven beyond a reasonable doubt, you don't even consider intoxication. It can be a defense to counts 5 through 7. The 2 where he's charged with being criminally responsible in the aggravated battery. But in that particular case, the mens rea or the intent must be shown as the person acts knowingly. That's all. Not intentionally, just knowingly. And what is knowingly? The person is aware of the nature of the conduct or circumstances that exist when the person is aware that conduct is reasonably certain to cause themselves. So it's basically aware. You're aware of, you have to be aware that a crime is being committed before you can be criminally responsible for it. It's not a high standard, but you have to be aware. Now, Dr. Lippman, of course, told us that in his opinion that you'd have to be unconscious not to be able to do a knowing act. Let's look at Mr. Beatty's, the evidence in this case. Jabari McKenzie, he said, yes, we were drinking in the room and you had to had something to drink. We were buzzed. Said we did this every other weekend for a year. But no, he was walking. He was communicating. Wasn't any blackout. Courtney heard. You heard her. She went up right before this incident happened. Knocked on the door. He comes to the door, greets her in his boxers. He said nothing unusual about that. And you heard Quella Royster. What did she say today? Yeah, she was asked to walk him up to the room, and yeah, she walked him up to the room. But then what did she say? I said, did you tell me yesterday once you got the room you didn't think he was that drunk? She said, yes. And what happened in the room? Said, well, he started coming on to me, making moves on me. And I told him, no, I didn't want to do that. And he stopped. He was aware. And of course, you've got him texting. You saw the text, the quesadillas and nachos, everything spelled out. Fine, he's texting that with Miss Royster.
The defense did not withhold any details about the suspect's future action.
But then Quella Royster, there's little things in trials you have to pay attention to sometimes, little nuggets of stuff. There was Quella. She'd gotten into it with her roommate up there. Corey was there. She calls him the next day at 1:30. What does he say? He talks to her for 11 minutes about it, says he's sorry it happened and everything. And I specifically asked her, did he ever say to you, what are you talking about? Not at all. Not at all. He didn't say, I don't remember anything. He talked to her for 11 minutes about what had transpired at 2 a.m. before this attack. She talked about aggravated rape and said we hadn't proved it. Well, you saw vivid screen, vaginal and anal penetration with his finger of Corey Beatty. Clear, no question about it. So, count 3, that's the fellatio. What proof do we have of that? Well, you have Mr. McKenzie, and he said, I saw him put his penis in his mouth. She kept pressing. He said, well, he had his hands on it, he pushed it in her mouth. I may not have been able to see his, but he had his hands right there and he put it in her mouth. And then you have the picture of him sitting there, right on top of her face. You can see her hands laying out like that. He's on his knees. Now, do you think he didn't touch her with his on her mouth or her face? That's all that's required. He doesn't have to penetrate her mouth. Look at the law on fellatio. And you think he just hovered there an inch above it with that photograph? Of course not. Mr. McKenzie told you that's what he saw. The photograph corroborates what he saw. And after that, what did he do? He went back to have sex with her again, indicating that he had possibly gotten some type of erection from placing his in her mouth. Count 4, penetration with his. You saw the video. You saw him making motions. You saw where his hands were in relationship to her. I submit that alone. He doesn't have to have an erection. You read the law, it says the slightest penetration is sufficient. Got a lot of guys on here, so I guess I can talk about football. It's breaking the plane. That's all it is. Doesn't have to be erect. Just barely penetrate whatsoever. I think that video in itself is sufficient for you to convict of that. But Mr. McKenzie tells you he went back and did it again. And would he have kept trying if he wasn't successful? And then he said, we talked about it the next day. And he acknowledged that he'd penetrated her. So let's talk about Jaborn McKenzie. They want to make a big deal out of him not being in the photographs. Well, because he was taken. And what do we know from the evidence, Mr. McKenzie? He's no angel. I'm not saying he's not in the wrong, but he didn't touch her. You didn't hear him say anything on the video. You didn't hear Mr. Prelude say he ever heard him say anything. And he went in and out of the room. And he came back, but he went in and out of the room, so he wasn't even there the whole time. And he told you, yes, I lied. We tried to stick to our stories. But, you know, they say you must corroborate him. And that's true, because under the law, he's an accomplice. He is an aider and abetter, and the judge will tell you that. He's an accomplice. He was there assisting, offering to assist. He was taking photographs. He was participating, just like all these guys were. So let's look at what's required. This is what is required to corroborate an accomplice. Now, he could have said, you know, you could have somebody come out and say, I did this armed robbery and Governor Haslam was out in the car driving for me. You couldn't convict Governor Haslam unless you saw him on video or somehow you connected him to the crime. So there must be some corroborative evidence fairly legitimately tends to connect the defendant with the crime charge. That's all that's required. Evidence that connects him to this crime. Surveillance video is enough showing him going in a room. That's it. But you've got so much more. Videos, photographs. I'm not going to show them, but, you know, to say that we can't corroborate his testimony is not what the law requires. Let's look at a little bit of what corroborates his testimony. Well, a video, obviously. You see Mr. Beatty live and in color doing his thing. Photographs corroborating, showing all the various acts that he committed. Surveillance video corroborates him, showing him coming and going and all the various things. Matt Prelude corroborates what he said. Remember, Mr. Prelude talks about, we're going to He heard the same thing Mr. McKenzie testified to. He heard the same statement by Mr. Vandenberg that he couldn't get an erection. He heard those. He heard the porno playing. He heard all of that. That corroborates what Mr. McKenzie was saying, and also he acknowledged there were in the room. They belonged to Mr. Vandenberg.
The verdict may be, please do not have any outburst. All right? They should be in here momentarily.
All rise.
All right, please be seated. I see that juror number 6 has the paperwork which indicates that you are the foreperson. Is that correct?
Yes, sir.
Have you reached your verdict?
Yes, sir.
Would you please stand and read your verdict?
You want me to start with the first one?
Count one, yes.
All right, count one. On the aggravated rape, we done not guilty. And we charged him guilty with guilty of aggravated sexual battery.
All right.
And on count two, we charged him guilty of aggravated. Count three, we got him not guilty of aggravated rape, but we charged him guilty of attempted aggravated rape. On count four, we charged him not guilty of aggravated rape. We charged him guilty of attempted aggravated rape. On count five, we charged him not guilty of aggravated rape, but we charged him guilty of facilitation of aggravated rape.
All right.
On count six, we charged him guilty of aggravated sexual battery. And on count seven, he's guilty of aggravated sexual battery.
And is that your considered verdict?
Yes, sir.
All right, you may be seated. I'm going to ask each of you the same question, starting with juror number 7. Is that your considered verdict?
Yes, sir.
All right, juror number 14, is that your considered verdict?
Yes, sir.
Number 13, is that your considered verdict?
Yes, sir.
Number 12, is that your considered verdict?
Yes, sir.
Number 11, is that your considered verdict?
Yes, sir.
Number 9, is that your considered verdict?
Yes, sir.
Number 8, is that your considered verdict?
Yes, sir.
Number 1, is that your considered verdict?
Yes, sir.
Number 2, is that your considered verdict?
Yes, sir.
Number 3, is that your considered verdict?
Yes, sir.
And number 5, is that your considered verdict?
Yes, sir.
All right. I want to thank all of you. I do want to speak with you very briefly, but I want to thank you for your service here. Thank you very much. You are, well, let me ask the attorneys, anything from either side?
No.
All right. Thank you. You are excused. I'll see you momentarily. All right.
All rise.
All right. 2 is a Class A felony. I am required to revoke your bond and place you into custody until the sentencing hearing, which will be, Madam Clerk.
May 13th.
All right.
Well, please, I'm gonna be out of the country on May 13th.
How about the next Friday, May 20th?
It's close, I'm not sure. I don't have my calendar right here. Gonna be gone for 2 weeks, starting, I think, 5th of May, something.
Starting what?
The 5th, I think.
You'll be back on 19th then.
Yeah, I think so.
We'll set it for the 20th, and then if you get back and it's different on your calendar, just email me.
Thank you.
Okay. Well, that's it. Have a good evening, folks. Well, I don't think anyone disagrees that this was a horrible and senseless crime. Consequences to all parties have been everlasting and will be everlasting. I've been in this position for almost 13 years, and I have seen thousands upon thousands of cases, many of which were very horrible cases. Now I had to make decisions about thousands of cases. And I've done that in the sincere belief that I was being fair with all parties involved, not only the victims, but the defendants as well as their families. Because when any crime occurs, particularly a crime such as this, a lot of people are affected. It's not just the victim and the defendant, it's the families that are affected and others as well. I know my experience these last 3 years, I've had one unique experience I've had these last 3 years is the number of strangers as well as friends who have approached me about this case. Of course, I couldn't discuss it, but I've had so many to tell me this one single thing. This is such a sad, sad case. And it is. But I couldn't say that to them. All I could say is, I can't discuss the case. But it is a sad case. It is one of the saddest cases that I've ever encountered. And I've been in the legal business for 32 years. And I've seen so many cases. And this is one of the saddest, clearly. But people, for whatever reason, young people in particular, make decisions in their lives that are often life-changing. And as a result, I have to make life-changing decisions with regard to them. And I do so. I do so as honestly and as fairly as I can. And I try to always do the right thing. And I look at the possible consequences of individuals' behavior. And I weigh it against, although I look at each case individually, I also weigh it against all of the other kinds of cases that I have to deal with and the different kinds of defendants. Because all defendants are not the same. Many defendants who come in criminal court, as you probably know, are those who have a long history of criminal behavior, starting oftentimes as juveniles and graduating to adult crimes as they reach adulthood. And I see many of those, but I also see individuals who are one-time criminals, so to speak, who have gone out and done something that they knew that they should not have done, but they did. And then they have to suffer the consequences for doing so. And I've had to deal with that time and time and time again. And I do. It's my job. And I do it because I took an oath to do it, as I will have to do today with regard to this young man. All of the defendants in this case basically have life sentences. After they get out of jail or prison, they will be on the sex offender registry for the rest of their lives. And that's a life sentence in and of itself, because if you have a real understanding about what individuals go through, although they put it upon themselves, what they go through when they're on the registry, And I have knowledge of that. I serve on the offender treatment board. I've done so the last 3 or 4 years, so I know what offenders have to deal with on a daily basis. And it's not a good experience, as it shouldn't be. But if you're on it for life, that is in effect a life sentence. Court has weighed all of the factors, the enhancement factors, mitigating factors. The court has read the letters in support of Mr. Beatty. The court has listened to the witnesses today, the victim today. And so the court is keenly aware of how people feel with regard to this case. This is a serious case, and it's going to affect these young people, and it will hopefully have a positive effect on other individuals who may find themselves with this kind of opportunity, but take a step back and say, well, I'm not going to do that because I know if I do it, I'll go to the penitentiary, or I will shame my family. And so I do what I have to do. In this case, of course, the state pointed out TCA section 4035-103, subsection 1B, which applies that confinement is necessary to avoid depreciating the seriousness of the offenses, and confinement is particularly suited to provide an effective deterrence to others who commit similar offenses. And having said all of that, with respect to counts 1, 3, 4, 5, 6, and 7, the sentence will be 8 years. With regard to count 2, the sentence will be 15 years. And these will run concurrently with one another, but count 2 is 15 years at 100%. That's going to be the judgment of the court.
In 2022, at a rally in Austin, former Army Sergeant Daniel Perry shot and killed Garrett Foster, an Air Force veteran. This case has sparked significant attention in both the courts and the public eye. Now, the final verdict is approaching. After 30 years, Garrett Foster's family has finally received justice, leaving them speechless with emotion. Let's listen to their account of this tragic event.
Hi, my name is Anna Mayo. During this trial, our family has been lashed out at, but something that has been lost in the media was that my brother was a veteran. He served in the Air Force. And Daniel Perry was in the military, and he took an oath to serve his country. My brother took that same oath, and the same oath that my dad took, and both of my grandfathers, countless uncles, and both of my great-grandfathers took when they served our country. My father served in the Air Force in 1987, and then he re-enlisted in 1991. He currently works as a private military contractor for the Department of Defense. And my uncle has served in the Army, just like Daniel Perry, since 1987, and is currently a private contractor for the Army. Most of his time was spent in the NCOIC. When there's respect to a veteran, my family will be the first to give it. So to hear so many people blatantly disregard that Garrett was a veteran and tear his character apart, like my mom said, has been the hardest part of this. But I truly hope that everyone has taken everything that they've seen throughout the process of this trial. And I hope that they see my brother for more than what Daniel Perry and his team has described him as, because Garrett was great. And if you look into his life, you will see that for yourself. I want to thank the Travis County District Attorney's Office and Travis County District Court. And I would like to thank Judge Brown for not allowing politics into his courtroom, because none of that mattered. It was Garrett Foster. His life mattered. And I'm glad that a lot of people, all of the people on the jury, agreed with that. So, yeah, that would be it for me. Thank you.
The jury faced numerous legal challenges, but when they finally delivered their verdict, the atmosphere in the courtroom changed completely.
The verdict of the jury is as follows. The verdict of the jury: we, the jury, find the defendant Daniel Perry guilty of the offense of murder as alleged in count 1 of the indictment signed by the foreperson. Verdict form number 2. Verdict of the jury: we, the jury, find the defendant Daniel Perry not guilty of the offense of aggravated assault and weapon as alleged in count 2 of the indictment. Please be seated. Would either party like these juries be polled? We would not. And so, with the exception of Ms. Cackler and I'm going to ask each of you. Juror number 1, is that your verdict? Yes. Juror number 2, is that your verdict?
Yes.
Juror number 3, is that your verdict?
Yes.
Juror number 4, is that your verdict?
Yes.
Juror number 5, is that your verdict?
Yes.
Juror number 6, is that your verdict?
Yes. Yes.
Juror number 7, is that your verdict?
Yes.
Juror number 8, is that your verdict?
Yes.
Juror number 9, is that your verdict?
Yes.
Juror number 10, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 12, is that your verdict? Thank you. At this time, I'm going to ask you all to be excused to.
Judge Manuel.
Yes, sir.
Before you release the jury, I'd like you to poll the jury as to whether any of the alternates participate in the deliberations.
Did any of the alternates participate in the jury deliberations in violation of the court's instruction?
No.
Juror?
No.
Juror number 2?
No.
Juror number?
No.
Juror number 5? Juror number 6?
No.
All right. With that, I'm going to ask you to retire to. I know it's been long. I'm going to ask you to retire to the jury room one last time, and the court will be back there to visit with you momentarily. I have to take some business up with the lawyers. All right. Thank you so much. Yes.
Certainly to include the devastating impact by this tragic incident upon all those personally affected. This court sentences you to a term of 25 years in the Texas Department of Criminal Justice. You will receive credit for whatever time you've previously been in custody. That concludes these proceedings. And Mr. Perry, you have to step over and give the clerk a thumbprint. Thank you.
We do have to reallocation.
Okay.
It sounds like the judge had to deal with quite a challenging situation. It must have been quite a scene in that courtroom.
The recommendation on count 1 is 12 months,
10 days to serve, a $300 fine, 40 hours of community service.
So she served 1 day. We want her to serve the rest of the 9 days.
So based on her history, this would actually be a second battery against the same victim. She's required to serve a minimum of 10 days.
Miss Lewis, if you realize the first time that this ain't the right relationship with you, why would you stay in it? If you're in love and you end up having to go before a judge, that's some foolishness. Just acknowledge that you picked the wrong person to be in a relationship with and keep it moving and learn how to co-parent, take some classes, but keep it moving. And if you've ended up in jail twice, he ain't the one for you. You shouldn't have had to fight him for anything. He don't have no legal right to that child. Man, get your life. Because y'all gonna have to raise this child, and y'all can do that successfully without foolishness. That's all I'm saying. Law says you are the only legal parent if he has not legitimized that child, and if y'all weren't married at the time of the child's birth. All this back and forth with Mr. What's his name, that's just foolishness. Once you become a mother, you're too grown to throw hands unless you're protecting your child. We clear? Yeah. That's your primary responsibility, is to be there for your baby. All right, so I'm going to accept your plea of guilty. I'll send you to 12 months to serve 10 days credit for 1 day.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.